Ladies and gentlemen, the American jury and Bulldog Nation, please be sure to subscribe to the Bulldog Show on YouTube. Today, I would like to cover criminal law. Just so you know, and I should say this in front of every one of these short legal seminars, is I do have a lot of experience in each of these fields. I've done it, so to speak. Every single day in the news, you hear about criminal charges against somebody, local, national, and you've learned a lot from following those cases and those stories. I'm going to give you an overview, I'm going to give you some tips, and I'm going to give you some warnings. First, let's start, because it's where it all begins, with the charges. Every single charge that could be filed against you, or a loved one, or somebody you know, is one of these three situations. One, they're innocent, and they know that they're innocent. Two, they're guilty, and they know they're guilty. Or three, they're guilty, but they're not so sure that the government can prove that they're guilty. If you're honest with yourself at the outset, which one that you fit in should govern everything you do from that point forward. For example, one of the things that I've advocated that you don't hear coming out of the mouths of very many lawyers is this. If you are innocent, sing it from the mountaintops. Cooperate, talk. You do everything you need to do. I can't tell you how many times that advice that I gave to somebody saved them from getting indicted. Guess what? A lawyer might want you to be indicted, so then they start making money. The next thing we need to cover is the law involved. The law involved can either be city police officer, county police officer, or county sheriff, a state, could be a state police officer, or you're talking about feds. Also, by the way, state could also include, there was recently arrest for shooting a deer. It could include the wildlife officers. The feds involve the FBI, the DEA, ATF, alcohol, tobacco, firearms, all kinds of federal agencies. ICE could be involved. The next I want to cover is the crime. The crime can be one of three issues. One, a violation. You pay a fine, traffic ticket. A misdemeanor. Generally, a misdemeanor is a charge that you're not going to be able to, you don't have to serve any more than a year. Those are misdemeanors. Or they involve an amount of property theft, for example, under $300. Then you have a felony. Obviously, a felony is a more serious. And each state decides what's a crime, and Congress decides what's a federal crime. It's all part of a code. All state crimes, all federal crimes are passed by the legislature. They don't get invented. It has to be passed by the legislature. The arrest. If you're ever arrested, and this is something very important, everybody calls up a lawyer and says, they didn't read me my rights. Folks, when you're arrested, they don't have to read you your rights. The only time they have to read you your rights under the U.S. Supreme Court Miranda decision is when you are in a custodial interrogation. They take you down to the police station. They want to interview you. That's when they have to read you your rights. Right to remain silent. Right for legal counsel. Anything you say can and will be used against you. Just being arrested does not require you being read your rights. That gets asked all the time, so let's clear that up. Once you're arrested, a judge, and there's usually a judge scheduled, is going to set your bond and bail sometimes overnight. If you get picked up for an issue, like a traffic issue, a DUI, usually you're going to get a bond and bail overnight, and you can bond yourself and bail out. More serious crimes, when you go to your arraignment, you're going to then have your bail set. Bail is determined, by the way, on the following things. It's determined, bond and bail is determined when, how much you, chance of fleeing, like you're a flight risk. How serious is the crime? Are you a career criminal? Or you're a pillar of the community? You've heard that argued on TV. That's what it's all about. But bond and bail can be set. The whole purpose of bond and bail is to keep you from fleeing and making sure you show up. For example, you don't have any money and grandma puts up their farm. They hope that you're not going to flee and grandma loses their farm. Public defender, I want to throw this in there. If you're broke and you have no money, no assets, no research, no ability to pay, you might be qualified for a federal or a state public defender, depending on the situation. Public defenders do know the system very well, and most do a very good job. However, it is true that a public defender is not getting paid the same amount as a private counsel will get paid, and also that a public defender, depending on the workload, what jurisdiction you're in, they may have, maybe this one we need to get pled out. But you know what? If you don't have the money, unfortunately, you're stuck with a public defender whether you like it or not. That's the system that we have. But at least our system requires you to have legal counsel. You got that right, and we assign you somebody. The next, the criminal complaint. Sometimes you're not arrested and you're just charged with a criminal complaint. A traffic ticket, for example, was kind of like that. You're handed a ticket when you get cited. Sometimes you're charged with a criminal complaint. Dr. Durrani was charged first with a criminal complaint, was indicted later. The indictment. An indictment is simply the charge, just like a criminal complaint, that lays out what you're going to be charged with. By the way, criminal complaints and indictments can be changed. They can be supplemented. So you could be started out charged or indicted with A, B, C, and they had D, E, and F. Who indicts? An indictment is with the prosecutor meeting with the grand jury. Every state, every county, every federal jurisdiction, they have a grand jury. The prosecutor usually presents the case to the grand jury with just the law enforcement officer. The defense is usually not there. However, you can ask the prosecutor, if you know you're under a possibility of an indictment, and you can go testify to that grand jury. If you're innocent, I encourage you to do so. But it's not done very often. But the bottom line is there's an old cliche about you can indict a ham sandwich. Well, that's why. The defense doesn't get to show up and defend themselves. Grand jury sits there and listens to the cop, tells them, okay, this is what we're going to do. But a grand jury indicts. Also, a grand jury proceeding is secret. There's some exceptions to that. Arraignment. Once you're charged, you stand before a judge, you identify yourself, name, address, date of birth, and the judge will decide bail, bond, tell you when your next court date is, and you get to enter a plea. The plea that you can enter in arraignment is guilty, get it over with quick. Not guilty, which is usually done, gives you time to feel things out. And also something called no contest, which is allowed in a lot of jurisdictions, including Kentucky. Nola contendere, no contest. It means that you acknowledge that there's enough evidence to convict you, but you're not going to fight it. No contest. Also called an Alfred plea, if you ever hear that word. Preliminary hearing. Oftentimes when you're charged with a felony, you have an opportunity, and the court has to make a determination whether or not there is probable cause for that charge to go forward. And you get to have what's called a preliminary hearing, which can be waived. But at that preliminary hearing, your defense attorney can cross-examine the cop to determine whether or not there's sufficient evidence for this charge to go forward. An example is I once represented a man accused of spanking his kid with a belt out in Boone County. And at the preliminary hearing, we got Judge Collins to dismiss the case at the preliminary hearing. It's rare, but a preliminary hearing can be used to get a case dismissed if the judge says there's not sufficient evidence for this to go forward. A preliminary hearing is also an opportunity for your lawyer to find out what's going on, some of the facts, some of the evidence. Pretrial. A pretrial is simply the final hearing before your trial. That's usually where it's put up or shut up, take a plea or not take a plea. But a pretrial is simply the final court hearing status before you go to a trial. Before after a pretrial or before a pretrial is called discovery. In a criminal case, they have to turn over everything they got, even exculpatory evidence, which means evidence that might help your cause. They have to turn it over. But the discovery process in a criminal case is the exchange of documents and information. Rarely, unlike a civil case, rarely are there depositions. But you know what? Part of the discovery process is your lawyer getting an investigator or himself and going out and talking to people, interviewing witnesses, talking to witnesses. But the discovery process is an open process. Everything's supposed to be exchanged. Then you've got the plea. If you're innocent, plead not guilty and stick to it. There's some exceptions to that, even if you're innocent and they offer you some plea bargain that who cares, get it done. I've represented people where I was like, not worth fighting it. But a plea is important because if you're charged, for example, of a federal crime, you get brownie points in the sentencing guidelines if you plead guilty instead of fighting it and later get convicted. That absolutely makes no sense to me. You got a constitutional right to defend yourself, and then you get punished for defending yourself. By the way, I found out the KBA does the same thing to you. How does that make any sense? You get punished for fighting. Witnesses. Witnesses are black and white, common sense. Who might have some information? I want to stress this to you. This is a rule of thumb if you're trying a case. I know what I'm talking about. When in doubt, leave it out. You know what? You can have this great case going and you feel the need to call this one witness to ask him one question to shore something up. And on cross-examination, they blow the entire case. If you've proven yourself innocent or not guilty or you've met your burden, you know what? Leave it the hell alone. Documents. Documents get exchanged as part of that discovery process, but you just can't throw you have to have a document verified by somebody. It's called hearsay. So people think, oh, can I file an affidavit? No, an affidavit doesn't do you any good at your trial. You have to have any document authenticated as true and accurate. It has to be relevant. Prior bad acts. This comes up all the time. Bill Cosby got convicted because that judge allowed all the prior bad acts, and the Court of Appeal said, nah, baby, nah. Here's the crux of this. What matters is whether you're guilty of doing this criminal case, not whether you're guilty of 5 other criminal cases. Here's a little criminal tip. If you are convicted of a felony, they're allowed to ask you, have you ever been convicted of a felony? And you got to answer yes or no. If you lie about it, then they can ask you about the details. Media strategy. You know, a lot of these judges put the gag order on, a lot of judges don't. Media strategy is really, really important. When I represented a high-profile Northern Kentucky woman charged of a crime, and they were given interviews and were saying they're not going to be able to prove it, they're innocent, everybody was like, wow, Bulldog, I was reading the comments on social media, Bulldog wouldn't be doing that if they were guilty. David Dooley, still think he was innocent. I let him do interviews from jail. Never see a lawyer do that. By the way, I still think if I represented David Dooley, he would have been found not guilty the first time. It's a tragedy. Next, search and seizure. You heard about warrants. You have to get a warrant from a judge to do search and seizures. And the bottom line is that's, you know, is there possible probable cause? They got some documents. The standard's pretty low. You can go to a judge and get warrants, search and seizures, all that kind of stuff. Search warrant, search the house, all those type of things. It's pretty standard stuff. The Fourth Amendment is what gives you protection against unlawful search and seizures. So the Fourth Amendment comes into play in any criminal case. Also, the Sixth Amendment. The Sixth Amendment gives you the right to a speedy trial. You also have the right under the Fifth and Sixth Amendment to cross-examine your accusers, put on your defense, and don't forget the Eighth Amendment also gives you the protection of not excessive bail and excessive punishment. Speedy trial. Speedy trial is part of the Sixth Amendment. You usually waive that. By the way, a lot of times in a criminal case, you don't want a speedy trial, so you waive the speedy trial. In fact, here's another tip for you. In my experience, generally, the longer a criminal case goes, the better it gets for the defendant. Innocent until proven guilty. That is the standard. That is the law. Innocent until proven guilty. It's also called presumption of innocence. However, I say this all the time when I voir dire a jury. How many of you really think somebody who's charged with a crime, arrested by cops, and is sitting in that chair is really innocent? Everybody thinks they're guilty, or they wouldn't have been charged. I have fun with that at trials. Beyond all reasonable doubt, the standard of conviction is the highest standard, and the whole concept behind this, the American jurisprudence, is we would rather have an innocent person, or excuse me, a guilty person go free than an innocent person be locked up. And that's a good standard to have. That's not the way it is in the Soviet Union. So you have to prove beyond all reasonable doubt. You ready for this? You don't get to explain to the jury what beyond all reasonable doubt is. It's simply this mythical beyond all reasonable doubt, which means if you got reasonable doubt, you should find him not guilty. Irrational reasonable doubt, unreasonable doubt isn't. Confront accusers. I've already covered that. You have a right to confront your accusers. By the way, there is no more important weapon in defending yourself against a crime than cross-examination of the accusers. Anybody can tell you that watching TV, but if you go down and watch a live trial or a hearing, it's amazing how sometimes you'll be sitting there in a courtroom, you're a lawyer waiting for the next case to be called, and somebody's testifying, you think, man, this guy's toast. Then after cross-examination, you say, well, that was a bunch of crap. It's hilarious. Cross-examination is the great truth seeker. Trial. I think I've already covered a trial, so we won't cover it again. I want to explain a few terms for you. In Kentucky, misdemeanors in traffic go into what's called district court. Felonies go in circuit court. In Kentucky, it's the county attorney that prosecutes the traffic and misdemeanors and the first intake for a felony, and the Commonwealth attorney prosecutes the felonies. In Ohio, you have a municipal court for the violations, traffic court, as well as misdemeanors, and it's the common police court that handles, just different terms, but it handles the same thing, the felonies. In Ohio, the prosecutor will be the city solicitor. For felonies, it'll be the county attorney. In the federal cases, you're before the U.S. Federal District Court. It's just like being the trial court in Kentucky and Ohio, and it's in the jurisdiction where you are, Southern District of Ohio or Eastern District of Kentucky. And the United States Attorney, which, by the way, are appointed by the President of the United States, is the prosecutor for federal cases. Sentencing. In Kentucky, every crime, if you're convicted of, has a gauge of 1 to 5 years, 5 to 10 years. The jury can make the recommendation. The judge is the final decider. The judge can ignore that jury sentencing's recommendation. Same thing in the federal system. The federal system has these guidelines that are much more stringent than a state court. This is kind of crazy. If you're ever charged with a crime, you're better off really fighting the battle in state court because the judges have more leeway. You can get, there's more avenues, more funny. But if you're ever convicted, you're better off being convicted in federal court than you are state court because the federal prisons are better than the state prisons. So that, for what it's worth, I throw that out at you. If you're found guilty, you have a right to appeal. Sometimes the judge will keep you in jail. I think this is awful. If you've got a legitimate basis for appeal, guess what? Sometimes you're serving your time while you're waiting for your appeal. That's tough, isn't it? Can you imagine that? You win your appeal, but you've already served like 2 years by the time your appeal's heard. By the way, that is a real beef that I have in the system. The appellate system needs to be sped up like times 10. Prosecutor discretion. Like it or not, in every state, every county in the United States, prosecutors have prosecutorial discretion to even take the case, bring the case. And by the way, once you're charged, it's the state's decision, not the victim's. It's the state's right to pursue that case. And you know what? One of the great things it's important to elect good prosecutors or appoint good prosecutors is to have somebody who has the right discretion of who to go after and who to not. You got to make tough choices. Unfortunately, in this country, all the prosecutors handling anything coming out of Washington use their discretion never to file any charges. It's a travesty. Criminal defense lawyers. All right. I should have put this in the front, but those of you that have watched this entire thing are going to get a good one. Criminal defense attorneys, there are some good ones, and there's a lot of shysters. You know what they do at the outset? They scare the hell out of you, so you're so scared. Why? You're facing 1 to 5. You know, I need a $20,000 retainer. When they know, based on that jurisdiction, that you're going to plead guilty and you're never going to serve a day. Be leery of criminal defense lawyers scaring the hell out of you to pay them a lot of money. Also be leery of criminal defense attorneys paying them a whole hell of a lot of money when they know from the outset they're going to plead you guilty. Folks, there's criminal defense lawyers around town that never try a case because they're checking and they're scared and they don't want to take their time. So they charge all that money, blah, 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 and then they say, oh, I think you ought to plead guilty. Why waste your time? If you're guilty, make a good deal in the very freaking beginning. You probably get the best possible deal. Be leery of defense lawyers jacking up their fee by scaring the hell out of you. I got some stories I could share with you, but that's another day. Takes too long. If you're convicted of a crime, a governor can pardon you from a state crime or commute your sentence. That means shorten it. Same thing, the United States, the president has that power to do it. It is unfettered. They can do it, period. And there's people that want to try to undo that. It's really a joke. The president and the governor deserve that type of power. It's a shame when it's abused. I think Bevin abused it big time. I think Obama abused it big time. But that's where the cookie crumbles. Parole. If you're charged with a crime in the state of Kentucky, you're subject to probation and parole, and there's a parole board, and you can make your pitch. The whole idea of parole board is whether or not, you know, you've learned your lesson, you're going to be a good citizen, so forth and so on. There's some people that are never going to. Charlie Manson dodged the death penalty. He was never going to get parole. Finally, jail and prisons. I can tell you right now, it matters where you go. If you want to commit a crime, you might want to think about where you're going to commit the crime. What jurisdiction? Hamilton County? When I was in Hamilton County Justice Center for 8 days, everybody in my pod, G-Pod, wanted to get the hell back to their state prison in Ohio. They hated the Hamilton County Justice Center that freaking bad. State prisons, folks, are awful. And that's how bad they thought of the Hamilton County Justice Center. Federal prisons, especially people that, these white collar crimes, they get a year and a half, 2 years. I mean, you serve it at a low minimum security. You can actually walk off sometimes, but you know, you don't because you want to serve your time. Look where Martha Stewart, you know, how she served her time. If you ever commit a crime and you're convicted, hope it's a federal crime because it's a lot better than state prison. Nobody wants to go to Eddyville or LaGrange if you commit a crime in Kentucky. So that's an overview. It's not everything, but it gives you a nice view of the whole criminal process. I hope you've enjoyed it as much as I've enjoyed giving it to you. And if you're ever charged with a real serious crime, especially if you're innocent or you don't think they can prove it, contact Deters Law. This is the Bulldog. Every dog has their day. Have a great day.